The Supreme Court has just announced that it is refusing the effort from Donald Trump's team to stay a decision on Trump's sentencing in his hush money criminal case here in New York, scheduled for Friday. Again, the Supreme Court now refusing to stop former President Trump's sentencing. The president-elect was scheduled to be sentenced after being found guilty on 34 felony counts for falsifying business records as it related to so-called hush money payments to the former porn star Stormy Daniels ahead of the 2016 election. You'll recall during the summer of 2024, during footage like this, when the former president was coming to and from a criminal courtroom here in New York, that he vehemently denied the allegations against him. But ultimately, a jury of his peers found him guilty of falsifying business records. And that preceded the election, where most voters found that they still...
What's happening, people? Welcome. Dr. John Podcast is here, so this is happening right now. Trump is simultaneously a convicted felon on 34 counts and yet has faced no punishment, while the Supreme Court effectively killed the most serious criminal case against him. It sounds like legal fiction, but this is the actual paradoxical status of a sitting president. Donald Trump is the first president in American history convicted of felony crimes. Not accused, not indicted, convicted. A jury of 12 ordinary New Yorkers looked at the evidence in the hush money case, deliberated, and found him guilty on 34 felony counts of falsifying business records. 34, not one, not five, 34 separate felonies. That conviction is real. It's on his record. It will be in every history book ever written about this era. And yet, here's the twist that breaks people's brains. That same man is sitting in the Oval Office right now. And thanks to the Supreme Court, he may never spend a single day in a courtroom for the most serious charges he's ever faced.
Most American voters found they still wanted him to become the next president of the United States. So it set up this highly unusual moment in American history where an incoming president would be sentenced in a criminal case in New York. So before Friday's sentencing, Donald Trump's legal team actually requested that the Supreme Court intervene and stop the sentencing on the grounds that the Supreme Court ruled that a president cannot be held accountable, or even a former president, for any actions that are part of an official act of a presidency. And so, as we look into the decision from the Supreme Court, we can read you a portion of it now. And it essentially says that the application for stay has been denied. And it says it's being denied for two reasons. First, and I'm quoting here, the alleged evidentiary violations at President-elect Trump's state court trial can be addressed in the ordinary course on appeal. So the Supreme Court saying that it does not need to intervene in this sentencing.
Can you believe this? A convicted felon shielded by the presidency? Both things at once. This is the impossible contradiction that defines American politics in this moment. Now, follow the timeline with me, because this is where the story gets truly wild. Back in the spring of 2024, the Supreme Court hands down a blockbuster immunity, ruling that gives presidents absolute immunity for core official acts and presumptive immunity for everything else. That decision gutted and stalled the federal January 6th case, the big one, the election interference case, pushing any trial past the election. Critics said the court did the unthinkable. They said the court had essentially placed the president above the law. Then, just days before his second inauguration, Trump's lawyers raced back to that same Supreme Court and begged them to block his sentencing in the New York hush money case.
Because any of the issues that the president-elect has can be addressed on ordinary course on appeal. The second reason the Supreme Court provides is that, quote, the burden that sentencing will impose on the president-elect responsibilities is relatively insubstantial in light of the trial court's stated intent to impose a sentence of unconditional discharge after a brief virtual hearing. Now, that's a reference to the latest developments out of this criminal court in Manhattan, where Judge Juan Merchan has said that it is likely that the sentence imposed on President-elect Trump will be what is described as an unconditional discharge. Moments ago on the Daily Report, we had a conversation about what that means, and it effectively means that Trump, as someone who has no prior criminal record, no previous incidents. And of course, being a man of high stature as a former president and now as an incoming president, wouldn't have been sentenced to jail time. You're seeing an image of...
Surely the court that gave him the immunity shield would save him again, right? Wrong. In a 5-4 order, the court said no delay, no rescue, go get sentenced. And so, on that January morning, Donald Trump stood before Judge Juan Merchan as president-elect and was sentenced as a convicted felon days before taking the oath of office. That had never happened before in 250 years. Come on, you could not write this as fiction. Nobody would believe it. But here's where it gets even stranger. The sentence itself. Judge Merchan gave Trump something called an unconditional discharge. Now, if you've never heard that term, buckle up, because most people haven't. Unconditional discharge means no prison, no fine, no probation, nothing. The conviction stays on his record forever, but there is zero punishment attached to it. No fines, no prison, no probation, but still a convicted felon.
Judge Juan Merchan here. And so the Supreme Court is effectively saying that because the punishment will be an unconditional discharge, and because it estimates that Trump's concerns can be addressed on the normal course of appeal, it is now denying Trump's effort to have the Supreme Court intervene. Our CBS News legal contributor, Jessica Levinson, joins us now with more on this. Jessica, after so many months of watching the trial and calling it unprecedented, moments before sentencing, this is a remarkable development, but help us better understand this decision by the Supreme Court.
Well, I think it's in some ways a non-decision. They're saying, no, we're not going to take this up. We're not going to push pause. We're talking about a state criminal case. And we know that you, President Trump, have asked us to intervene on, frankly, I think some somewhat creative theories that a president-elect is entitled to immunity in addition to a president. And they, I think, very predictably.
And Merchan explained why. He called the case truly extraordinary and said this was the only lawful sentence that wouldn't infringe on the highest office in the land. Translation, I can't punish a man who's about to be president, so the conviction itself will have to be the punishment. Are you kidding me? 34 felonies, and the sentence is basically just the paperwork. Meanwhile, regular people are sitting in prison right now for falsifying far less, and everybody watching knows it. So that's the impossible split we're going to unpack today. On one side, a locked-in felony conviction, a public sentencing, a permanent historical stain that the Supreme Court refused to prevent. On the other side, an immunity ruling from that same court that has slowed, shrunk, and shielded the far more serious January 6th prosecution maybe forever.
Decided not to get involved because there really is not a live federal question right now. This was an invitation for them to take up, I believe, an issue outside the scope of their previous decision. So as people know, President Trump was convicted in the hush money case. He is now set to be sentenced tomorrow morning. He had gone to the Supreme Court and other courts saying, pause this sentence, don't sentence me. And part of his theory was that based on the Supreme Court's decision that presidents can enjoy immunity from criminal prosecution, that he, as the president-elect, should enjoy immunity from sentencing.
So what then does this mean when it comes to sentencing come Friday? They do note that, Judge Juan Merchan has indicated that the sentence will likely be an unconditional discharge. Help us better understand what that means and why the Supreme Court feels it's significant in this decision.
One hand delivered the humiliation, the other hand delivered the armor. And in this video, we're breaking down exactly how both happened, the 5-4 order, the immunity doctrine, what official acts actually means, why the January 6th case got wrecked, and the appeals still quietly moving through the courts that could reshape all of it. Because I promise you, most people only know half of this story. They either think Trump got away with everything, or they think he got nailed. The truth is weirder than both. Let's get into it. Let's slow down and take this apart piece by piece, because the details here are everything. Start with the conviction itself, because it's the foundation of the whole story. The case was about hush money payments and the paper trail used to disguise them in business records. Now, whatever you think about that case, and people have very strong opinions, here's what's legally undeniable. A grand jury indicted, a trial happened, defense lawyers fought every point, 12 jurors heard the evidence and voted guilty on every single count. That's the system working exactly the way it works for everyone else right up until the moment it was time to hand down the sentence. And that's where this case left the normal universe and entered uncharted territory. Because between the conviction and the sentence, something enormous happened. Trump won the presidency again, so the court suddenly faced a question no American court had ever faced. How do you sentence a man who is about to become the most powerful person on earth? His lawyers had an answer. You don't. They fought to delay the sentencing entirely. And when the New York courts wouldn't budge, they went all the way to the top. An emergency request to the Supreme Court stopped this sentencing before the inauguration. And this is the moment I want you to really understand, because it's the moment everyone assumed they knew the ending to. This is a court with a conservative supermajority. A court that includes 3 justices Trump himself appointed. A court that had just months earlier handed him the biggest immunity ruling in American history. Everybody, and I mean everybody, expected the rescue. And then the order came down, 5-4. Deny. The court refused to block the sentencing. The majority's reasoning was almost brutally practical. They said Trump hadn't shown he was entitled to an automatic stay, and they pointed out that the burden of the sentencing was relatively insubstantial because the judge had already signaled there would be no prison time. Read between the lines of that. The court was essentially saying, relax, you're not going to jail, so stand there and take your sentencing like everyone else. 2 of the conservative justices crossed over to make that majority. 5-4, 1 vote. That's how close Trump came to never being sentenced at all. So the sentencing happened, and Judge Merchan delivered the unconditional discharge. Now let's be honest about what that sentence is and isn't, because both sides spin it. Is it a punishment? Materially, no. No fines, no prison, no probation. Trump walked out of that proceeding exactly as free and exactly as rich as he walked in. If you or I were convicted of 34 felonies, our lives would be over. His didn't change by $1 or 1 day. That's the special treatment side, and it's real. But is it nothing? Also no, because the discharge locked in the conviction. Merchan called the situation truly extraordinary and said this was the only lawful sentence that wouldn't infringe upon the highest office of the land, meaning he threaded the only needle available. Any real punishment would have collided with the presidency and probably been overturned. The discharge, though, is bulletproof. It made the conviction final, formal, and permanent. Donald Trump is a convicted felon, and no amount of spin changes that record. So who won that day? Honestly, both and neither. He kept his freedom. History kept the felony. Now, flip to the other half of this story, because this is where the Supreme Court's role goes from referee to game changer. The immunity decision. Here's what the court actually held in plain English. First, for actions inside a president's core constitutional powers, the stuff only a president can do, there is absolute immunity from criminal prosecution. Absolute. Cannot be charged ever. Second, for other official acts, things done as part of the job more broadly, there's presumptive immunity, meaning prosecutors have to overcome a heavy presumption before they can even use those acts in a case. Only purely private conduct is fully fair game. Now think about what that framework did to the federal January 6th case. The election interference prosecution, the most serious legal threat Trump ever faced. That indictment was built substantially on things Trump did while president. Conversations, pressure, communications about supposed election fraud. And the immunity ruling effectively wiped out parts of the indictment tied to those communications and raised the bar dramatically on everything else. The whole case got largely paused and kicked back down to the trial judge, who had to regain jurisdiction and then sort through the wreckage, deciding line by line what counted as official and what didn't. The delay did exactly what delay does. It pushed any trial past the election. Voters went to the polls without ever seeing that case tried. And once he won, a sitting president facing federal trial, that door, practically speaking, slammed shut. Now here's where most people misunderstand this story, so lean in. People treat the Supreme Court's behavior as a contradiction. How could the same court hand him the immunity shield in June and then refuse to save him from sentencing in January? Hypocrisy, right? Actually, no, and understanding why unlocks the whole thing. The immunity ruling was never framed as being about Trump the man. The court framed it as being about the presidency, the office. The majority's argument was that presidents, all presidents, need protection from criminal prosecution for official acts, or every president would leave office staring down indictments from political enemies. You can agree or disagree. Plenty of legal scholars think the court went way too far, but that was the logic. Protect the office. And that exact same logic explains January. The hush money case was about conduct the courts treated as private, falsifying business records around personal payments, not official acts, not the office. So when Trump asked the court to block that sentencing, he was asking for protection as a man, not as a president. And 5 justices said no. The through line isn't pro-Trump or anti-Trump. The through line is the office gets the shield. The man does not. Now, does that distinction feel like a lawyer's comfort when the practical result is he avoided prison in one case and may never be tried in the other? Fair. But if you want to actually understand this court instead of just yelling at it, that's the map. And the story is not over. This is the part almost nobody is following. The legal machinery is still grinding. A federal appeals court told a judge to re-examine whether any of the evidence used in the hush money trial touched immunized official acts. Because here's the wrinkle. Even though the conduct was private, some of the evidence at trial involved things from his time in office, testimony from White House aides, statements he made as president. And under the immunity ruling, if immunized official act evidence contaminated the trial, that could in theory become grounds to challenge the conviction. Now, to be clear, as of right now, the conviction and the discharge still stand. Nothing has been overturned. But the appeal is alive, which means the one concrete legal consequence Trump ever suffered, the felony record itself, has a thread hanging off it. And his lawyers are pulling that thread with everything they've got. So even the humiliation half of this story has an asterisk on it. That's how far the immunity decision reaches. It's not just shaping future cases, it's reaching backward, trying to unwind the past. And here's a truth about the legal system that this whole saga proves better than any law school lecture ever could. In high-stakes cases, the calendar is a weapon, maybe the most powerful weapon there is. Because think about what actually defeated the January 6th case. It wasn't a jury saying not guilty. It wasn't evidence falling apart. It was time. Every appeal, every immunity question, every trip up and down the court system burned months. The immunity ruling alone sent the case back down for a painstaking sort through of official versus private conduct. Months more. And Trump's legal team understood from day one that they didn't need to win the case in court. They needed to win the race against the election. Push the trial past November, win the presidency, and the case dies of natural causes. That's exactly what happened. So when people ask, did the system fail? Here's the precise answer. The system didn't rule wrongly. The system ruled slowly. And slow at this level is the same as never. That lesson is now public knowledge for every powerful defendant in America. And that might be the most consequential legacy of this entire fight. So that's the full picture. A jury conviction that made history. A 5-4 order that forced the sentencing. A discharge that punished nothing but recorded everything. An immunity doctrine that kneecapped the January 6th case. And an appeal still trying to erase the conviction itself. Now let's break down what it all means. Who really won? What it says about the rule of law and what's still coming. The conviction is history. Literally. Whatever happens next, one fact is now welded into the American story. A president was convicted of 34 felonies by a jury of ordinary citizens and was sentenced days before his inauguration. That has never happened before. And the Supreme Court, the one institution with the power to stop that sentencing, chose not to. 5-4. That matters beyond politics. It means the record exists. The verdict sheet exists. The sentencing transcript exists. Historians, courts, and future generations will work from documents, not from spin. For years, the debate was whether a president could even be tried like a normal citizen. The New York case answered that. Indicted, tried, convicted, sentenced. The system proved it could run the full process on the most powerful man in the country. What the system could not do, as we're about to discuss, was attach any actual consequences. And that gap between process and punishment is the whole story of this era. The unconditional discharge is where accountability quietly died, and everyone should be honest about it. Look, I get the judge's dilemma. Merchant said it himself. This was the only lawful sentence that wouldn't collide with the presidency. Jail the president-elect? Chaos. Fine him? Litigation forever? Probation? Who supervises the commander-in-chief? So the discharge was probably the only real option on the menu. But let's not pretend about what it means. 34 felony convictions produced nothing. No dollar paid, no day served, no condition imposed. And every regular person watching drew the obvious comparison. People do serious time for falsifying records at a fraction of that scale. This is where the two-tier justice feeling comes roaring in. And honestly, it's not paranoia, it's arithmetic. The most generous read is that the office of the presidency, not the man, forced the courts into leniency. But the practical lesson lands the same either way. When the presidency is involved, even a felony conviction becomes decorative. And here's the darkest version of that lesson. The legal system just demonstrated that the ultimate get-out-of-consequences card in America is winning an election. Think about what that incentivizes for him, for whoever comes after him from any party. The immunity ruling is the biggest expansion of presidential power in modern history, and its main victim was a trial that never happened. Let's be crystal clear about the mechanics. The January 6th case, the federal election interference prosecution, was the heavyweight. That was the case about alleged efforts to overturn an election. And it never reached a jury, not because the evidence collapsed, not because a jury acquitted, because the immunity ruling rewired the rules midstream. Absolute immunity for core powers. Presumptive immunity for official acts. Key parts of the indictment, including communications about supposed election fraud, effectively wiped off the board. The rest sent back down for months of sorting about what counts as official. The calendar did the rest. Delay past the election. Election won. Trial gone. So when people say the courts held Trump accountable, remember the asymmetry. The hush money case, the smaller one, went the distance and produced a punishment of 0. The January 6th case, the enormous one, was stopped before the starting gun. Supporters call that protecting the presidency from partisan prosecution. Critics call it the court doing the unthinkable. But on the raw scoreboard, here's the fact. The most serious allegations ever leveled at an American president were never tested in front of a jury. And because of the immunity doctrine, they may never be. This isn't finished. 3 live wires are still sparking. First, the hush money appeal. A federal appeals court ordered a fresh look at whether immunized official act evidence tainted the trial. If that challenge ever succeeds, the conviction itself, the one solid consequence in this whole saga, could be thrown into question. Watch that case. It's moving quietly and it matters enormously. Second, the immunity doctrine itself is now loose in the world. Every future president inherits it. Every future prosecutor has to design cases around it. Legal scholars are still fighting about where absolute ends and presumptive begins, and those boundaries will be litigated for decades. The court didn't just rule on Trump, it redrew the blueprint of the presidency. Third, the sentencing, because that 5-4 order cuts the other way too. It established that a president-elect can be sentenced, that the office doesn't erase a jury's verdict before Inauguration Day. A future president from any party now lives under both precedents at once, shielded for official acts, sentenciable for private crimes. Those two rulings are going to wrestle with each other in American law for the rest of our lives. So who actually won here? Honestly, Trump won where it counted most. He stays free. He stays president. The biggest case against him is in pieces. His only sentence cost him nothing. If you're keeping practical score, that's a rout. But it's not a shutout. The conviction stands, and the felon label is permanent unless an appeals court erases it. The 5-4 order proved even his own appointees won't rescue him automatically. And the moral record, the rulings, the verdict, the sentencing transcript is carved in stone for history. Who lost? Start with the idea that no one is above the law, because that phrase now comes with footnotes. Add the January 6th prosecutors, whose case was dismantled from above. Add public trust, because half the country now believes the system protected a criminal, and the other half believes the system persecuted a president, and both halves trust the courts less than they did before. That erosion doesn't reset when this presidency ends. It compounds. And in fairness, let's give the strongest version of the other side. Defenders of the immunity ruling argue it's not about Trump at all. It's about stopping an endless cycle where every outgoing president gets indicted by the incoming party. They say without protection for official acts, no president could make hard decisions without fearing prosecution the moment they leave office. Defenders of the discharge say the judge respected both the jury and the Constitution, preserving the verdict while protecting the functioning of the presidency. Those are serious arguments made by serious people. But here's the question they have to answer. If the combined result is that a president can be convicted of 34 felonies and suffer 0 punishment and can avoid trial entirely on the gravest charges by winning an election, then what exactly does accountability mean at the top? Because a rule that only binds the powerless isn't really a rule. It's a suggestion with a dress code. The system has spoken in 2 contradictory voices. One voice says, "You are guilty, and history will record that forever." The other voice says, "But you are also untouchable, and the consequences will not reach you. Both statements are true in the same legal system at the same time. That is the reality we are all living with right now. And that reality, more than any single verdict or ruling, is what will define the American legal system for generations to come.